Welcome back. You're listening to Conservative Conversations with Tom Saruf. My guest today is Paul DeHart, who is a professor of political science at Texas State University, where he specializes in teaching and studying natural law, the American founding, early modern political theory, social contract theory, the grounds of political authority and obligation, and the relationship between religion and political order. He is the author of Uncovering the Constitution's Moral Design, and more recently, The Social Contract in the Ruins, Natural Law and Government by Consent, which is the subject of our episode today. And we talk about the social compacts theory, the organic theory of political society, moral realism, moral conventionalism, the thought of Thomas Hobbes, John Locke, the Salamancan Thomists, St. Thomas himself, Aristotle, Johannes Althusius, and many other thinkers. Paul is a very careful political philosopher, and I think that will come through in the episode, so we hope you enjoy.
Join the best in the movement. It's Conservative Conversations with ISI, educating for liberty since 1953.
Paul, welcome to Conservative Conversation. Thanks for joining me.
Thanks for having me. Happy to be here.
Congratulations on this book, The Social Contract in Ruins. I got a chance to read it, and a really fantastic, thorough, thoughtful book. And I'm going to start where you start in the book, which is, where does the debate really lie over this question or this model of the social contract and social contract theory?
Yeah, so let me be really precise about what's in view, since people use the phrase social contract or social contract theory in a variety of ways. I am focusing for the political, it's a political theory book predominantly, but there are some other things that one has to do. But I'm focusing on this specific claim that consent is necessary for political authority and obligations. As it happens, there are some theorists who would seem to treat consent when it comes to political obligations, or some theorists who, in the realm of moral philosophy, would broaden this out to ought, who seem to think that consent is necessary and sufficient, or maybe just sufficient for political authority and obligation, and in some cases for moral obligation. And consent theory itself fits into this broader model of covenant, I would argue, or it has connections to this, and folks who began to think about political order and its foundations in terms of a covenant, which was an agreement. And you see this certainly with separatists who come across the sea. You see this with Puritans. You see this with what we might call the federal theology wing of the Reformation from Zurich, Switzerland. But you also see this in some Catholic counter-reformational theorists like Cardinal Bellarmine, and you see it in the thinkers out of the Salamanca school in Spain. Suarez is the name most people will know. For folks who do philosophy, they might know Molina, Soto, Vasquez, or some other names associated with that school. These folks, like the Salamancan school, Johannes Althusius and the Reformed tradition, on down the line, Algernon Sidney in the late 17th century, kind of martyr for Republican form, and John Locke, these folks all think of consent as necessary for political order. They don't think of it as sufficient, and they don't think of it as necessary and sufficient. The theorist Thomas Hobbes has many strands, but in one of his strands of thought, which seems to rest even ethics on principles that we make, seems to treat consent as either sufficient or as necessary and sufficient for obligation or ought. Now, there is a voluntaristic law of nature derives from divine omnipotence thread that moves through Hobbes. There's also a sense in which he says the moral obligations that we have are ones we have because we assent to them in his later work, something he denies in earlier work, affirms in later work. But there's this passage in a work of Hobbes, who is in political theory generally considered a kind of watershed, this line in which he says that pure sciences, like geometry, are demonstrative and a priori, prior to experience, because they derive from principles that we make. I can imagine Euclid is rolling over in his grave as Hobbes is writing, but because it derives from principles that we make. And then he says, physics is mixed mathematics, i.e. it's not a pure science because it has both math and our experience factors in. And then says ethics and politics are like geometry, pure sciences, these sciences of just and unjust, right, because it derives from principles that we make. Well, ultimately, this makes our will, if it's really from what we make, necessary and sufficient for moral obligation. And so you really end up resting consent on something that derives just from will. In many ways, Hobbes shapes a whole tradition of thought that comes after him. But other consent theorists have begun with the claim not that consent is sufficient for either moral or political obligation, but that it's necessary. In fact, John Locke has a passage, and I think there are problems in Locke's thought, but Locke has a passage in which he argues that moral construction, the idea that we make moral principles, is circular reasoning. It begs the question. So what I'm trying to argue is where this project sort of began was looking at what does it take to give a coherent account of consent. And as I'm looking at this, what I discovered, some of which I was aware of, but the more I dug in, the clearer this became over a number of years, but that the consent theorists, like American founders and framers, especially James Wilson in his lectures on law, you find this in Alexander Hamilton and others, they hold that a coherent theory of consent is wedded to a moral law where the moral law is objective, real. It's not something that we create. It's binding on all people at all times and places. And what I'm seeking to show then is that this is necessary for any coherent account of consent is necessary for political obligations and authority. And the idea is basically that with consent, we are applying the moral norm of keeping our promises. The fancy phrase, promissory obligation. The big idea is just we ought not break faith. We ought to keep our promises. Consent theory gets sort of all of its moral capital from saying, okay, we ought to take that serious. Given human equality, some people are not the rulers of others by nature. So it is natural for us to have political rule in a kind of Aristotelian sense. But who rules whom is not given by nature when it comes to political thought. And Cardinal Bellarmine and Suarez are among folks who affirm that, along with Richard Hooker, not just John Locke later on or other folks, that human beings are equal. Because they're equal, no one has the right or the title, the claim to rule others or others to obey them by nature. Aristotle says this, right? Aristotle says, insofar as people are equal, he doesn't necessarily affirm that people are equal. In fact, he seems not to. But he says, insofar as people are equal, then nature doesn't establish who rules who. They should rule and be ruled in turn. Well, early Christianity says human beings are equal by nature. One that I like to throw out there is Lactantius, the tutor to Constantine the Great's son, 4th century figure. Ambrose of Milan, with whom St. Augustine studied. Gregory the Great. These were all folks who affirmed a fundamental natural moral equality of human beings. And so if we say, insofar as people are equal, then authority is not given by nature, right? Who rules whom is not given by nature. And in fact, people are equal. then we have a logical argument there that entails it's not given by nature. The foundation must be something else. Aristotle doesn't go beyond they should rule and be ruled in terms, kind of popular sovereignty. But the consent theorist and Richard Hooker before John Locke says, given human equality, their assent is necessary. But it's not just their assent is necessary, but they wed this to an objective moral framework, a real transcendent good. And I would argue that those who would eschew it, there are folks later on who want to say, people they disagree. You get John Rawls or someone like this that says people fundamentally disagree about the good, and so we need to come up with a plan that is neutral with respect to competing and incommensurable conceptions of the good, and we can't rely on any particular conception of reality. And I think the vision most people get of consent theory is trying to solve that problem. But at its foundation, and for the American founders and framers, consent applies the moral norm of promissory obligation, and moral norms require a real, objective, transcendent good. Hobbes, of course, whether or not he's a kind of theist, he might be a kind of alchemist, will deny that there's any real transcendent objective good. He'll define good by nature as subjective. He'll say that good simply means an object of desire, and evil an object of aversion for us. And then in the Commonwealth, it's relative to the law, the will of the sovereign, a kind of corporate person exercised by the one, the few, or the many. But what he's doing is making good and evil relative and subjective, right? And ultimately founding ought on some instance of will. It might be our will, principles that we make. It might be the will of the sovereign state or mortal God, as he calls it, or it might be the will of omnipotent power, irresistible might, but it's grounded on will, not a real objective transcendent good. And so my argument, I think, is this. That sort of position is incoherent. It presupposes its own denial. The $1 million phrase that philosophers use is it's self-referentially incoherent. It presupposes what it rejects. And so any shot at a viable account of consent must have a real and objective good that it presupposes. And not doing that makes it incoherent. But you might say, why not just abandon consent theory? There are, I think, a lot of folks today who would say, well, isn't this just Locke? And I'd say, it's not just Locke. It's grounded on equality. It's grounded first on a kind of Aristotelian insight. Insofar as we're equal, who rules whom isn't given by nature. Hadley Arcus has a wonderful phrasing of this in First Things. Mm-hmm. And then so I think that's sort of a natural principle. Insofar as we are equal, it's not given by nature. We might need further insight to know that we are in fact equal, but I think drawing on some things in Scripture, the St. Paul in Christ, there is neither Jew nor Greek, slave nor free. You have some early Christians who espouse this idea of natural equality, which is really actually quite foreign to the ancient world. I know there are some folks who think, well, didn't the Stoics talk about natural equality? And you can see a reference here and there, but as Kyle Harper says in an essay on Christianity and freedom, for the Stoics, dignitas comes on a sliding scale. Some people have more, some people have less. It really takes, he turns to Gregory of Nyssa, to shatter the scales. And Christ says in the Gospels, what does it profit a man to gain the cosmos and lose his soul? And what can a man give in exchange for his soul? And Gregory of Nyssa says, you know what that means? It means that each soul, each psyche, each self is worth more than the whole cosmos. Well, this shatters the sliding scale, as it were, and is the ground of an extraordinary equality that I like to say really must be rendered its due. So I think one of the reasons that we have to take consent theory very seriously is precisely because I think that human equality is a real thing. I think we are equal by nature. I think it may take special revelation to get us to that insight. It doesn't take a special revelation to get to the insight. If equal, then nature itself doesn't establish rule. But I think once we have that insight, I think it locks in, as it were, and we have to take it seriously.
Hey there, listener. I wanted to take a quick moment to thank you for listening to Conservative Conversations. This podcast is a production of the Intercollegiate Studies Institute, and our mission here at ISI is educating for liberty. If you'd like to join us in fulfilling our mission, consider helping us by rating and reviewing this podcast on Apple Podcasts, Spotify, or wherever you listen, to help us reach more listeners like yourself. Now, back to the show. Well, that's a great starting point, and so much to unpack there. And I think hopefully we'll get to all of it in our time. I have a clarifying question, which I think will be a quick one. Is when we talk about social contract theory, is there any difference between the term contract, covenant, compact? Are these things interchangeable? I mean, they have different connotations, but if there are any differences, what would they be?
So there's one kind of historical way to get at this. The recently late Donald Lutz commonly said that Lutz had read more material from the 17th and 18th century in the American settlement and founding period than anyone else. I sort of think that's true. Lutz would say that in its historical usage, that a covenant would be used to create a community. Could be a primary community, all right? Could be like a congregation or a guild or something like that. Or it could be a secondary community. And then it would be used to link communities together. So congregations and families and guilds might join together to form a town, and towns might form together to form something bigger. Eventually you call it a province, maybe you call it a colony, and those might link together to form yet something more comprehensive, maybe ultimately the Commonwealth. And he would say covenants, whether religious or political, invoke a higher power, God or the king, right? And so if you're separatists and you're on the Mayflower, you might come up with what they called the combination or the covenant. They didn't call it the Mayflower Compact. You might come up with that because you're chartered, and maybe you plan to come up with that anyway, but you're chartered for Northern Virginia, and you're pretty suspicious that you're not in Northern Virginia, and you need to bond this community together, and you appeal to something, and they do mention the king, but they appeal to God. Lutz would then say that a compact is a kind of secularized covenant, and historically we come to it for religious reasons. That is, that Roger Williams and those allied with him in Providence and then Rhode Island believed that oaths were a form of taking God's name in vain and a kind of blasphemy. From Jesus, don't swear by heaven, it's God's throne, or earth, it's God's footstool. Just let your yes be yes and your no be no. And so they thought, well, we can't take oath. At all, to God or to the king. He was against the loyalty oath in Massachusetts at the time. So when we look at the Providence Agreement, which founds Providence, there's no appeal to a higher power. And so Lutz would say that the difference really between a covenant and a compact is whether or not there's an appeal to God or not. And this is where you get folks who might call the American regime an almost covenanted nation. You get an early president of Yale going around the country saying, I don't see reference to God in the Constitution, or what have you. But those terms can still nevertheless be somewhat interchangeable. It is certainly the case that Hobbes uses the term covenant, right? Locke uses the term compact. And it's not till Jean-Jacques Rousseau in Le Contrat Social that we get the term social contract as the pervasive term. As you might say, Hobbes walks up to it. I think Hobbes is looking in his day at Puritan double covenant theory, Scottish Covenanters, these different groups, and these different groups have said the community is formed by covenant, and the king is appointed by a second covenant. If we're talking about the Puritans in England, for a double covenant theory. And oh, by the way, Charles broke that covenant, and he can be deposed and even executed. And Hobbes, who detaches sovereignty, which is an idea already sort of moving with James the First and others. Hobbes, as C.S. Lewis says, is the first person to detach sovereignty, the modern theory of sovereignty, from monarchy, right? And so one of the things he's doing is saying the sovereign, be it a king, so he's concerned that Charles I has been deposed by appeal to covenant. But whether it's a king or it's an aristocratic assembly or a democratic assembly, Hobbes says the sovereign is not party to the covenant and is therefore not bound by the terms of the covenant. The covenant creates the sovereign; he's not party to it, as it were. So I think that Hobbes is actually trying to the idea of covenant's already out there. He's trying to radically reconfigure it in a way that eliminates double covenant theory. Are the separatists, the Puritans, New England, some of the folks settling the middle colonies, the South, Virginia and South catches up, I think, a little later on this in terms of development. Those folks are really double covenant theorists, by and large. The separatists, the Puritans, what have you. Locke is a kind of double covenant theorist. That is, he does it. His parents were Puritans. He doesn't make direct reference to that sort of thing, but the Dutch revolutionaries were double covenant theorists. He spent some time in Holland. It's, his theory is a version of. I don't think he ever read Althusius. There are a lot of scholars who think he's so close to Althusius he must have read him. I can't find the connection that he read him. But what's common to both of them is this sort of double covenant theory. Locke calls it a compact. So I think for both of them, what's fundamental, or all three of those terms, they can, in practice, bleed in and out of each other. There is some theoretical and even English law distinction that separates them, but they're all trying to get at the idea that consent is necessary for political authority and obligation. And I think John Symonds, with whom I don't always agree, of course, but is a wonderful Locke scholar at the same time. Symonds would say, the only coherent account of consent theory that we could offer, and what Locke really meant to offer, was consent is a necessary condition. Now, that also drives a key problem, as you say. What regime has the consent of all its people? Or of most of his people, or most of those it claims to govern, and that I call that the de facto problem. I think following or recovering the older tradition of consent theory that we find in some counter-reformational theorists and the Salamancans, that we find in Richard Hooker, that we find in Johannes Althusius, and that we find echoed in Sidney. Sidney, who is explicitly, he's not Catholic. He's at points he'll say even the Jesuits understood some things. He's an English Protestant, and he can't. I suppose he can't appear too friendly, but Sidney spends the opening pages of his discourses on government defending Bellarmine. It basically says defending Bellarmine against Filmer and patriarchy, and so you have these interconnections, and these theorists who say consent is necessary, it's not sufficient. Also required is a real objective moral law, and so the main point being agreement is the common thread, but in those earlier theorists, it's agreement as a necessary condition. It's perhaps drawing on Hobbes, and then we see some 20th century developments with a guy most people here listening might not know, Gautier, but then a name they might have heard of, John Rawls, right? These guys are versions of making consent sufficient for political authority and obligation, and for moral foundations too. Really, they think of and it's hypothetical consent too. Which we can come. Well, I'll say this here. a lot of people I think Hobbes is probably a hypothetical consent theorist. I mentioned that consent is a application of the norm of keeping our promises.
Hmm.
Uh, and what is hypothetical consent not? It's not an actual promise. It's not about, it actually keeping our promises. So the libertarian philosopher Robert Nozick, lifting a phrase from someone else, famously said that hypothetical consent or hypothetical contracts are not worth the paper they're not written on. Um, so I love that. I love that turn of phrase. I think that's right. I'm bound to keep promises I made. I'm not bound to keep promises I might have made or would have made, but have not in fact made.
Right.
Right? And hypothetical consent, perhaps the state of nature is so awful that I would have consented to leave it if I could have. I, in fact, have never done any such thing, but I would have done it, Well, great, but I haven't actually done it, and so it may be the case, I hope my wife isn't listening, that in some hypothetical possible world that I would have married somebody other than I in fact did. And now suppose that person comes to me and says, there are circumstances under which you would have married me, and so now you're bound. Would my wife have a legitimate complaint if I said, "Oh yeah, I guess so"? Well, of
Right.
course, I actually made promises to one person, and it doesn't matter what I would have hypothetically done. That may be a useful tool to think through things, like why we have the state or something like that. But nobody's bound by a hypothetical promise. So hypothetical consent isn't going to help generate real obligations, which brings us back to the problem of actual consent.
Yeah, and it has to be a real consent, whether expressly, I say the Pledge of Allegiance, or become a citizen, or maybe tacitly. And I think later we can get into the difference
Yeah.
between those two things and various problems or
Good.
challenges. But
Good.
I think where I want to start diving more into the de jure problem, or the theoretical issues, is why is it that social contract or social compact theory seems to, or that the idea of a social compact seems to be opposed to, or based, or rather, maybe not opposed to, but based on, conventionalism, as you described, and maybe you can describe what that is. So, I mean, we're not going to be able to get to everything that you talk about in your book and all the different theorists, but I think
Yeah.
one of the main ideas is that social compact theory is tied to this sort of, politics is built on principles that we create. And that's
Yeah.
a criticism oftenly wielded against it. So why is
Yeah.
it seem to be that way?
Yeah, and I think when people do deem it that way, they're making a mistake, which is to say they are accepting Hobbes and what descends from Hobbes as the social contract tradition, as if there's just one tradition, and maybe they'll say, well, even if you want to create another one, isn't that's the headwaters. That's where it really begins. To which I want to say, it's not. It begins in the notion of covenant, and covenant actually has older roots in Reformation theology, and not just there. Among the competing views of religion, one of the more interesting strains of the Reformation is a kind of recovery, and it's not Germany and Luther, it's not Geneva, it's more Switzerland, and it's not so much Zwingli, but it's Zwingli's successor, a guy named Bullinger, is a centering on the Hebrew notion of covenant, God's covenant with Israel. They want to think about morality in terms of covenant, or the Decalogue as God's covenant with man. But at the same time, Bullinger was educated in something called the Via Antiqua. There was the ancient way, the Via Antiqua, and the modern way, the Via Moderna. And the Via Antiqua had a realist view of the good, an objective view of the good. So when covenant in the Reformational period is sort of first conceived, as a fundamental element of theology at that time, it's wed to moral and metaphysical realism. So I think on the one hand, it's because of the way that a lot of political theory has been done and taught that makes Hobbes the beginning of the modern period. We start with Hobbes, and Hobbes, whether it's we make the principles, right, or our ascent, or the Leviathan, or divine omnipotence, it rests everything on will. And there is certainly something that happens in a major strain in the Reformation, I think, that pulls William of Ockham, the late medieval thinker, forward. William of Ockham, people are maybe familiar with Occam's razor. I don't know if I was colloquialized or caricatured as the simplest explanation is right. That he says we should not multiply hypotheses beyond necessity. I set that aside. Ockham famously says that the reason murder, theft, adultery, things like that are evil is because they agree with the prescription, because God has prescribed them. He said, but their opposites could have been morally obligatory if God had prescribed those. So, if you will, God has made it morally obligatory that we not commit murder, we not commit theft, we not commit adultery, because he's forbidden it. But he could have forbidden us to preserve life, forbidden us to respect property, forbidden us fidelity, and in those cases, those would have been wrong for us because God forbid them. And if preserving life is right for us, it's because God commands it. And he weds this to I think a theory of natural law, which is to say, God has ordained the moral order that we have, which the Decalogue captures. Murder is wrong, theft is wrong, idolatry is wrong. And he's ordained that we apprehend this by right reason, and given the world as he's put it together, these commands in no case fail, but there's this deeper ontology, but it could have been otherwise. God in his absolute power could have made our moral obligations different than they are by commanding differently. I think that what happens with Hobbes, and it's not everybody in early modernity, but you see this with Hobbes, and you see this sort of pickup later on, is that he is kind of a lightning rod for Occam's account of moral obligation and right and wrong. And I would call what Occam's position akin to conventionalism, right? Because it grounds it on will. If conventionalism commonly means it grounds it on our will, maybe together, maybe embodied in law and custom or something like that, you could call Occam's view a kind of conventionalism about morality because it depends on the convention of God's will. God has prescribed. Rather than, I don't want to say I'm dismissing God here, rather than the more traditional position which rests ultimately on divine wisdom and goodness, and views, if we might call it, instances of divine willing as exemplifying, as affecting divine wisdom and goodness, the way that James Wilson saw this. So I think on the one hand, it's that people begin so often with Hobbes, and then they say, well, isn't Locke really Hobbes? The answer is no. There are places where they line up. They're both metaphysical nominalists. They both deny real universals or universal essences, like humanness or something like that. But I mentioned Hobbes. Martin Luther called himself an adherent to the Via Moderna and a disciple of Occam, right? And he says we were having this big debate in the so-called Augustinian orders that were new. The term humanity, is there such a thing as humanity, or are there just individual humans? And he clearly sides with the camp that says there's just individual humans. In Luther's Bondage of the Will, he says that things are righteous or unrighteous because God commands or forbids them. I think you see in the Reformation competing strains, but what you see in modernity is every major thinker like René Descartes, for instance, or Boyle, or Thomas Hobbes, pick up on there are no real universals. Occam said that the notion of real universals was the silliest notion he'd ever heard of, the greatest error in philosophy. And you see the moderns pick up on this with a kind of hard anti-essentialism. And Hobbes will say, well, that means there's no such thing as goodness. Good is a name for objects of desire. Evil's a name for. So I think you've got Occam back here, Martin Luther, and a strain of whatever one makes of the rest of what Luther says. Martin Luther picks up on this, and by the 17th century, the anti-essentialism is fundamental here, and we're moving towards conventionalism. And people are also going to say, well, it's wars of religion. John Rawls, as he looks back, we got to come up with a political theory that allows us to solve for the problem created by this pluralism, and supposing that we aren't going to eliminate it by force. And he'd say, what's the pluralism about? And he might say religion, but he also means all of our views. Now, there is another strain here. You can find in the work of Plato consent theory in two places. Okay. One is in the mouth of Socrates in Crito, as one of three arguments for why he must not escape his punishment pursuant to the conviction of the jury by escaping. And the other is in Book 2 of Republic, and it's one of Glaucon's challenge to Socrates, where Socrates says that justice is good in itself, and justice is beneficial to the soul who is just. And Glaucon says, prove it. He gives three challenges. The first challenge is everyone wants to be able to act with impunity towards others. He says to harm others with impunity. I think what Plato's sticking in Glaucon's mouth is something like this. Everybody wants to get what they want regardless of if it harms others in the process. I want to be able to get what I want even if I trample others in the process. And I don't want others to trample me getting what they want. And it turns out the thing I want most is not to be trampled by others getting what they want, and the thing I want most is not to be harmed with impunity by them. And no one is strong enough to get what they want or to harm others with impunity and to keep others from harming them with impunity. So, says Glaucon, the standard account of the origin of law, political order, and justice and its principles is an agreement. I won't harm you with impunity if you don't harm me with impunity. So I think I'm getting an echo here. Just no. Okay. It just showed up. Okay. You can cut that. So I think what's going on here is that Glaucon grounds justice and law and political order in agreement or convention. And as it happens, Glaucon is one of Plato's brothers. Maybe he really means this position. Maybe he doesn't. I don't know. Maybe he's just challenging Socrates. There's some debate. But the sophists, a broad name for teachers in the Greek world, but Plato and Aristotle narrow it to a subset. So sophists, as Plato and Aristotle understand it, they ground justice, law, political order in convention. There is nothing beyond what we agree to. There's the principles of justice are just a function of our agreement, nothing more. Now that is not the only account of consent in antiquity. It is one account. The other account we find in Crito, where the laws say to Socrates, Socrates, you observed how we governed the place, how we governed Athens, and you chose to have children and raise them here, and you stayed more than any other Athenian. You were gone for some battles, very major battles, but other than that, you stayed in Athens. And we say that by remaining, when you could have left, you were free to go. Athens' law was wide open on this. You were free to leave and take all your property with you. Obviously not the land. By staying when you could have left, you have made an agreement with us to obey. And Socrates is imagining the laws making this speech to him. He seems to find it persuasive because he remains and he accepts this punishment. And of course, Socrates student Plato, Plato student Aristotle. Aristotle, again, who doesn't, I think, espouse natural equality, but says, with respect to those people that are equal, hey, if you're equal, um, uh, um, uh, political authority, who rules who is not given by nature. I think that we see two competing grounds for consent in antiquity, but a lot of people have associated consent with the sort of sophist version of conventional political authority grounded in conventions of justice. And certainly as we move towards modernity and then move forward from the 17th century, a lot of people look back to Hobbes. And I think a lot of critics of consent theory, I think unfairly, a lot of critics of consent theory have often, even loyalists during the American Revolution, perhaps, not been willing to look at Sidney, or not willing to treat Hooker as a serious consent theorist. One of the things I wanted to do in the book was lay out those passages in which Hooker says people are equal, and since they're equal, there is no other basis than their assent by which some might rule others, or you might establish political authority. And to the Salamancans, the American founders and framers who insisted on consent also rejected absolute and arbitrary power. You see this in Otis. He invokes natural law. He says the power of Parliament is not absolute. And Alexander Hamilton, who accuses the Loyalists, and some of them really sounded like Hobbes on sovereignty, actually. Samuel Seabury in places, for instance. Hamilton says that if we begin thinking about a kind of state of nature with no government, he says the problem, in his pseudonymous exchange with Seabury, the problem with Seabury's view is Seabury says in a state of nature there is no law and no government. And Hamilton basically says, what about God's law and God's government? He says, Seabury's position, the Westchester farmer, I think, Seabury's position depends on holding that there is no superintending principle that governs the universe. And if there is such a one, we must imagine that there is a law that governs every condition of man. That is a law that is right for everyone, everywhere, always. That means all states of affairs. That means in a state of nature. But at some point, we get to not only Hobbes and social contract theory, but the problematic Hobbesian interpretation of the American founding, and I think that's where a lot of this comes from. And I think a lot of people just are not aware of the broader tradition. There are not just me. There are folks like Quentin Skinner that I think should be read. I don't agree with Skinner's what's sometimes called his historicism, his philosophy of history. I think he's absolutely wrong. His detail work on folks like the Salamancans and the Dutch Revolution and England and things like that is fascinating. Is I think spot on.
Well, yeah, there's a lot of different directions I could take this in, but there's one I want to focus on, and then maybe we'll actually just put it to the side for a while and move on to a different thread. But this idea of the connection between Hobbes and Locke, and that ties in something you were talking about sort of earlier on in your answer there, and then again tied it back later, is it a Hobbes and Locke tradition? Because I mean, there's more to the American founding than just Locke.
Yes. Yeah.
I really we did an episode with Thomas West, and West just says, who the hell cares about John Locke? Like, now I know he likes John Locke and can understands and explains his theories, but he says, who cares? Focus on what the founders themselves said, and then decide what you think about the regime. But there is, so there's more to the founding than just Locke, but Locke does have a substantial play in explaining the theory. There's clear passages, even the Declaration of Independence. It's not word for word, but it's a very close paraphrase of things that Locke says in the second treatise. So do you have a Hobbes and Locke connection, in which case the founders are Hobbesians, albeit unwittingly or maybe without even realizing? Or is it a Hobbes versus Locke tradition, my understanding, at least, of natural right and history by Strauss is that Locke is some sort of esoteric Hobbesian. He follows Hobbes in certain critical ways, albeit in ways that I didn't fully understand when reading that book. But what's your assessment there? And it's something I know you talk about in the book as well.
Yeah. Yeah. So I think that what we have is in the realm of political theory and political principles, Hobbes versus Locke, or Locke versus Hobbes. And in some other things, they're aligned. That is, they both reject universal essences. So it's, if I take that to be the corollary or the same thing as nominalism, which only particulars exist, it's kind of hard nominalism. There are no essences or things in themselves, or for Locke at least, we couldn't, either they don't exist or we couldn't know them and it doesn't matter. They don't factor into our reasoning about what is. So I think that there is some shared epistemological ground, but at the same time, there's shared epistemological ground between John Locke and Bishop Berkeley, and Berkeley is an idealist, and there's immense difference between them, right? I think there's some shared metaphysical ground. And early on, in some early writings, Locke actually sounds a bit like an authoritarian, and Hobbes is, of course, famous for his theory of sovereignty. The Jean Bodin, the Frenchman, and Thomas Hobbes, the twin pillars of the modern theory of sovereignty. It is absolute, which for Hobbes means unlimited, and it is indivisible. And Locke sort of sounds like that early on, but as some his most important biographer, for instance, and others have noted, he moves away from that position. And I would argue that it's under the influence, in part, maybe not only, but under the influence of the first Earl of Shaftesbury, Lord Ashley. Locke became Ashley's pen. And there's definitely a move away there. So on the one hand, there's a shared theory of knowledge foundation, epistemology, shared metaphysical foundation, and I think, nevertheless, Locke is a house divided against himself. And I think this shows up in Locke's own account of ethics before we even move to political principles. So that Thomas Hobbes, right? There are no universals. So-called universals are general names that we give to particulars. This goes hand in hand with his rejection of goodness. Hobbes says nothing is simply and absolutely good or evil. There's no rule of good and evil to be drawn from the nature of things or acts themselves. Good and evil are just names for desire, objects of desire and objects of aversion. And then says there's no greatest good. There's no utmost aim, maybe like final end, such as is spoken of in the books of the old moral philosophers. I think he has in mind Cicero, and your Latinist listeners will forgive me for not saying Cicero. I just can't bring myself to do it. But Cicero's on ends, good and evil, or on moral ends, as it's translated, De finibus bonorum et malorum, or his on duties, De officiis, and Aristotle and the Nicomachean Ethics. I think that's what Hobbes has in mind. He's saying there's no good that is good for its own sake and not for the sake of anything else. And everything else we desire for it. No such thing, says Hobbes. Rather, the happiness of this life, the felicity of this life, actually, is what he says, is the satisfaction of one desire after another, where the satisfaction of a desire now is just a way and mean to a satisfaction of a yet later desire. So nothing is good for its own sake. There is no highest good, and this weds to, and nothing is, he says this again and again, nothing is just or unjust by nature. Justice belongs to humans and society, and in the state of nature, nothing is just or unjust, right or wrong, and this weds to an absolute theory of sovereignty. So with Hobbes, we have this sort of connection of ideas, right? With Locke, we have the anti-essentialism And in fact, he goes as far as to say, from the summit of humanity among created things, all the way down to the lowest speck of dirt, it's just a matter of degree, not kind, indifference. He then proceeds to deconstruct species and to deconstruct human species or humanity, which there's no such thing as humanness. Well, he relies in the second treatise on the species of man as a ground of equality, as a fundamental ground of equality. So you say, what's he doing there? And I think this means that there's a divide between his essay concerning human understanding and the metaphysics that he embeds in it, and what he has to say both about politics in the second treatise and what he has to say about ethics. Because he, in places, though he sounds like pleasure and pain might be the measure of good and evil in the essay, he explicitly, multiple times, but especially in his unpublished essays on the law of nature, or questions concerning natural law, two published versions of it, says that morality is not a function of agreement. It does not derive from principles that we make. To say that we are bound by an agreement is to turn an effect into a cause, and a cause into an effect. It begs the question, and so David Gautier, who's a major Hobbes scholar and one of the major 20th century figures of the social contract view of morality, that is, we make it, we construct it, normative constructivism as it's sometimes called, he's maybe the major figure in that, and he's a major Hobbes scholar, and he says Hobbes held that view that he espouses. And Hobbes, Scott, like Al Martinich, would disagree with him about Hobbes on this, but he said Hobbes held that view, and Locke did not. And he's right about that. Locke rejects the idea of morality as a construct. Moreover, Locke, by implication in places, but one place explicitly, rejects the idea that good and evil are created at all. He says that good and evil, or that justice, is not just a function of divine omnipotence, but justice is a function of divine omniscience, divine wisdom, divine goodness, and divine will or omnipotence. That is, he says you can't actually have divine justice if you separate God's goodness and God's wisdom from it. So you might say, well, if he rejects universal essences, shouldn't he reject an objective real goodness? Maybe as a matter of logical consistency, he should be a voluntarist. It's God's will that creates good and evil, in which case I'd argue the position is, as for Occam and Hobbes, incoherent, and I can get into that argument if we want to, but maybe that would be the consistent thing. But the fact is, he's not consistent about this. He treats good as an uncreated reality, and says that justice is not, what is right and wrong is not just a function of divine prescription, but nor is it a matter of our agreement. That would be incoherent. So he seems to hold that there's an objective reality here. He says in one place that human law without natural law would be arbitrary. There's no reason that we should follow it. It wouldn't be anything different than the law of a band of robbers or a tyrant. How does it get its binding nature? Well, if natural law turns out to be arbitrary, then the problem has just been pushed back a step. So I think that Locke realizes that if he makes good and evil a function of divine will, or right and wrong a function of divine will, it becomes arbitrary, and the problem he wanted to avoid with human law is back in play. The other thing is that Hobbes' position, nothing is just or unjust by nature. In the state of the condition of mere nature, right and wrong have there no place. There is no just or unjust. This goes hand in hand with absolute unlimited sovereign power. And Locke is, in the two treatises, very much opposed to this. He rejects absolute and arbitrary power. And in fact, his whole theory of limited government is we don't have absolute or arbitrary power over ourselves or others. because we don't own ourselves or others. God owns us and God owns others. And therefore, when we consent to create political society, we can't give more power than we have. We can only give limited power, power limited by the common good and natural law, or authority. And the only authority political society has, it receives on transfer by consent of individuals according to Locke. And so if we can only give it limited power over ourselves, we don't own ourselves or others. And he never says in chapter 5, the chapter on property, that we own ourselves. Some people say, doesn't he found property on self-ownership? And the answer is no. He never uses the word ownership. He uses the phrase a property. And in the first treatise, he distinguishes having a property in something, like humans in the goods of the world, and having proprietary ownership, having property as an owner, which he attributes only to God. And so he says God could enlarge humanity's share of the world after the flood, and so that Noah and his children can now eat animals. God's enlarging their power, their authority over that. But human beings, he says, don't have. They have property in things as a kind of liberty to use them, but that is not property as an owner, which he attributes only to God. So Locke's denial of self-ownership and the ownership of others in the second treatise in chapter 2, I think is consistent with what he says in chapter 5. Leo Strauss would disagree with me about that. But on this point, I'm right, Strauss is wrong. Did I just say that? True. Yeah. So the next thing I'd say then is that this sets up political society only gets the authority it has on transfer. We can only give to it limited power. It can only come to have limited authority over us. So what I'd say is that his political theory, I think, is maybe at odds with his metaphysics, arguably, and that he's inconsistent here. Locke himself said he was inconsistent in the essay concerning human understanding. He said there are inconsistencies. It took a long time to write. He got really offended. His friend Tyrrell shared the essay with the group of scholars at Oxford, and they said, "We think he's a Hobbesian," and this offended Locke. At some point, Newton read it, the essay, and wrote back to Locke, "You're a Hobbist," and Locke says, "You've reduced me almost to tears." And Newton writes back apologizing. He's like, I was having one of my episodes. I was at sort of a break, and I never would have accused you of being such a thing. And I think that Locke really did not want to be. But the important thing for me is, whatever he intended, his political theory is anticipated at every turn by theorists contemporaneous to and before him. Didn't he? Althusius, as Quentin Skinner proves, the Salamancans. In key places, Robert Bellarmine. And Nick Wolterstorff. I started. I disagreed with some of the Straussian reads on Hooker, in particular Tom Pangles. But I looked into this more after reading an essay by the luminary analytic epistemologist, philosopher of religion, and Locke scholar Nicholas Wolterstorff, and I began to dig deeper. And I think that Hooker really anticipates, and that it's a sincere invocation by Locke of Hooker. So what I'd say is, whatever Locke personally intended, all the elements of Locke's political theory are in theorists before him who are moral and metaphysical realists, who are before Hobbes, who are opposed to Hobbes, anti-Hobbesian if they come later, like James Wilson. James Wilson, in his lectures concerning law, will famously espouse a consent theory of government based on human equality, will reject Hobbes on law and political authority, will reject Blackstone for sounding too much like Hobbes as a command theory of law. I also say, as some scholars have said, that Blackstone seems to appropriate a Hobbesian theory of sovereignty, and Wilson says we can't have that. And Wilson will then say, by the way, as much as we might like Locke in certain respects, like consent and equality, we certainly can't embrace what he says in the essay concerning human understanding. Because if you start with the essay concerning human understanding, you'll end up with David Hume's radical skepticism. And Locke may have not meant to end up there, but that's where his epistemology ends up. That subverts everything. And so if we reject Hume and his radical skepticism, as we should, we must reject Locke's epistemology. So the American founders could make this this kind of subtle distinction, I think. And so the other thing I'd add is that Locke's political theory is not coherent on the metaphysical ground that he would give to it. And if Locke was a Hobbesian, that would render his theory incoherent. And I'm arguing that we can have a coherent theory of consent and government by consent and popular sovereignty, but that there is no Hobbesian basis for it. And so if Locke, even if he thought, I don't think he thought this, but even if he thought subtly, this is a kind of Hobbesian project, well, he's actually yanked the rug all the way out from under it. It's incoherent. And part of my argument is that Hobbes' theory is incoherent, and I have my own arguments. Jean Hampton has hers. But I would say in political theory, it is Locke versus Hobbes, even if they have some alignment in metaphysics. And that Locke's political theory requires a better metaphysics than he is willing to supply it with his anti-scholasticism, for instance, and his anti-essentialism.
Fascinating, all of it, because it almost sounds like there are two John Locks in a way. There's a Hobbesian Locke that it's probably not an accident that people read him as a Hobbesian, whether it's Strauss or Newton, as you mentioned, and then there's the sort of like the Locke that, Jaffa says something to the effect that like Locke is the best thing that you can get, or the closest thing you can get approximating Aristotle in the modern world. It's some paraphrase, but so there's and those things seem radically at odds with each other. So it's very fascinating because, in the conservative world, there are some who are, devout defenders of Locke. And there's the fun game of like, how can I make John Locke more based than your most supposedly based anti-Lockean conservative? And then there's the others who think that the social contract theory is, thoroughly in the via moderna, and completely unsalvageable. And I think these contradictions in Locke play a big part in that. And it's kind of as a student of philosophy, it's interesting to think about how there are various interpretations of these thinkers that are readable or relevant, that aren't doing violence to the text. And so that's not something I don't think I've ever encountered before. Now I do want to go, because you've sort of offered us an invitation to ask the question a couple of times. Is this explaining, because it's an argument you use, especially in the book, it appears again and again and again, this argument form that once you sort of unlock the argument, it's like you can see it everywhere, and you use it a number of times. Talk to us about the insufficiency of will as the basis of right. Why is it incoherent? And can you lay out that argument form for us?
Yeah, absolutely. So, and this is something I was working on beyond my first book, which was Uncovering the Constitution's Moral Design. And in a way, I had borrowed, if you will, from Plato and C.S. Lewis and reformulated to say, listen, the Constitution must presuppose a real good. And that's because, as Madison lays it out, it's a kind of majority sorting device, right? It's not Oliver Wendell Holmes, whatever the majority wants now, but it seeks to favor some kind of majorities over other, long-term, broadly distributed, on the hope that those will be reflective, rather than narrowly distributed, short-term, passionate majorities or selfish majorities or what have you. The argument that I borrow, that you can see in Abolition of Man or in Plato's Republic, among other places, the way I would put it was this: you can't distinguish among instances of will on the basis of will. And if you distinguish among instances of will, it must be on the basis of something other than will, on the basis of an ought, a real good other than will. And the Constitution makes this distinction between some instance of will, long term, by virtue of all the veto points built into the Constitution, broadly distributed over narrowly distributed short term ones. And so it must presuppose an objective, real good. And then immediately after that, which started as my dissertation, published in 2007, I started to think, I'd like a stronger argument for that, and I began to think of how it might apply to ought and obligation more generally. It looked to me, for instance, like if one reads Hobbes, well, as I've mentioned before, you can see passages that say ethics and politics, the principles of justice, from principles that we make, or he'll ground it on our assent, or what is public good and evil from the will of the sovereign. But ultimately, in chapter 31 of Leviathan, he says the real ground of the binding power of the laws of nature is omnipotence and irresistible will. The Kive is very clear that he has in mind divine omnipotence as the ground here. And it seems to me that the way to put together all the passages, as Francis Oakley does in Locke, not in Locke, in William of Ockham, that sound like divine command passages and that good and evil and the natural law passages is in a similar way that there is a law of nature or natural law for William of Ockham that has precepts that are absolute and in no case fail, but they are ultimately grounded. Their deep ontology is divine will. And as I was finishing the book Uncovering the Constitution's Moral Design, I thought, I have this argument, and I think it entails that Occam, who has a traditional law of nature, right? On the one hand, his law of nature is the same as Aquinas's, the same as the Decalogue's precepts, right? And the mechanism by which we know it is reason, and it's recta ratio, it's natural reason, it's right reason that in no case fails, and its first primary precepts are absolute. They are known to all insofar as we exercise reason. We could fail to exercise reason about some precept or other and miss it, but insofar as we exercise reason, we know it. There are secondary precepts that are known to most, maybe not always, and tertiary precepts known only to the wise. But then there's this deep ontology. This it all rests on divine command, prescription, and prohibition. And I thought, well, I've got an argument that might entail something here, but what I'd like to show is that Occam's position, which many say, well, isn't this just a distinction without difference between him and Aquinas? And maybe at the practical level, it might seem like that, but at the level of deep ontology, it's not. Can I show, is there a way to show that Occam's position, which I think is adopted by Hobbes, for instance, is self-referentially incoherent? That is, that grounding ought on will, whether my will, Arthur Allen left, Godlet, our will together, Protagoras, maybe Thrasymachus, the will of some of us who are really strong in the community, the will of the mortal God, as Hobbes calls it, the Leviathan, or sheer omnipotence. Is there a way to show that, as C.S. Lewis says in The Poison of Subjectivism, that a real, eternal, uncreated goodness is necessary? Now, in Christian theology, instead of saying, is something good because God creates it, or because God does it, or commands it, or does God command it because it's good? The traditional solution is to say is that God is identical with goodness, and with wisdom and eternal wisdom. But is there a way to show that the position that it's just power at the bottom is incoherent? And my father-in-law is a mathematician, and I was thinking one day. I know, but this is going to sound as bad as Descartes dreaming that he's staring at his hands. I was thinking one day about the set of prime numbers, right? The fact that it runs from 2, starts with 2, and goes to infinity, and yeah, Euclid provided a reductio ad absurdum for 2 ways of denying that. So the upshot is that set of prime numbers goes to infinity, like the set of odd numbers or even numbers. And as I'm thinking about this, I'm like, you can't distinguish one prime number from another on the basis of primeness, right? You can't distinguish 7 from 13 on the basis of primeness, or you can't distinguish 38 from 4 on the basis of evenness, or 7 from 13 on the basis of oddness. And it occurred to me, and I can't imagine it's only me, but I didn't find anything else. But maybe this is implicit as people think about this. To bring something to the surface, it occurred to me that this is true of sets in general, that you can't distinguish among the members of any given set of numbers on the basis of the property or properties that define the set, or on the basis of the predication of that property. Well, it occurred to me that we can also conceive of a set of all exercises of will, right? Some are of an individual, some are of a group. It might be an exercise of will to do something, like to go climbing at Rattlesnake Point in Canada. I did that once, and I think it did not occur to me that there might be rattlesnakes at Rattlesnake Point. I didn't encounter any, but as we were driving back, I thought, Rattlesnake Point. Anyway, to have a glass of Chianti, to read C.S. Lewis's Till We Have Faces, to play in a baseball game, to vote in an election, to sacrifice one's self, or potentially sacrifice oneself to save another, to perform the aria Morti Vieta in front of a panel of vocal judges at a jury. A group exercise, maybe the community, to build and maintain a road, or a school, or a park, or to have some kind of security for our community. And some acts of will are perhaps ones we'd call good, and some others malevolent. And the point is, we can have a set of all actual and possible instances of will, and that would be an infinite set. Well, the thing is that you can't distinguish among instances of will on the basis of will alone, because doing that would be distinguishing among the members of the set on the basis of the property by which the set is defined. It would be the same as trying to distinguish 7 from 13 on the basis of primeness or on the basis of oddness. So if we do consider some instances of will either to instantiate or to conform to an ought or obligation, and others not to, and maybe we consider some instances of will normative for others. Maybe it's divine legislation and natural law. Maybe we think that we create a political order with a constitution, and we consider the ratification and establishment of that constitution normative. not only for citizens, but for ordinary lawmaking. And maybe we consider laws made by a representative body pursuant to that Constitution, normative for the members of the community. Or maybe we have a vote of the community, a referendum on the law, and we consider that binding for our township or our city or what have you. We take some instances to be normative for others. But that can't be on the basis of will alone. So that if some instances of will are normative for others, then it must be on the basis of some property, some standard, some rule and measure, to borrow from Aquinas, that transcends the set and is normative for it. Well, once we get there, it means will alone can't create ought. Will alone can't create obligation. And then we say, well, okay, what are conventions? What are agreements? Those are instances of will. And qua will, or insofar as their will, they cannot create ought or obligation. But rather, insofar as we take some agreements to be normative, or insofar as we take it to be the case that we ought to keep our agreements, that can't come from agreement alone, because agreement is an instance of will, and will alone is unable to do this. For to take some instance of will to be binding or ought in some way is to ultimately presuppose a real good, and that makes what we might call voluntarist, will-based accounts of ought and obligation self-referentially incoherent. They really, for their coherence, depend on a real, uncreated, transcendent good. And so a coherent account of agreement, of conventions, of consent, and of keeping our promises, therefore requires at its foundation a coherent account of covenant. Covenant involves will somewhere. Maybe it's a bilateral covenant. If we speak of God's covenant with creation, it still involves will. For covenants to have any kind of binding property, it must be grounded in obligation. It must be grounded in a real good, a transcendent, uncreated, eternal good, which is a way of saying, there are a lot of folks who I think, whether they are in the realm of politics or ethics, meta-ethics, normative constructivism is sometimes they call it, constructed norms, or theology. There are a lot of folks who say, we don't really want to deal with Plato at all. We don't really want to deal with Hellenism and this notion of the good. And for a lot of them, it is covenant versus the Greeks almost, to split apart the early Christian synthesis and the medieval synthesis. It's the covenant model versus not all figures frame it this starkly, and certainly Bollinger at the Foundation didn't. But what I want to establish, a lot of people today think that way. I sometimes think, Tom Wright, if you're listening, that N.T. Wright thinks a little bit along these ways, covenant rather than. And what I want to argue is that this argument shows that covenant in any of these areas, including political foundations, depends for its coherence on a real, uncreated, eternal, transcendent goodness.
That's perfect, and it takes us then to another, like a beautiful logical proof, which is applicable in all sorts of cases, because there are all sorts of sets that are claimed as the predicate or the basis upon which something's has moral force, or has the force of our being bound to recognize it as such. But so that's not just true of will, but of other variants. But that's another way of saying that the only way we could have a consent-based political system that commands our obligation or has rightful authority is if it's based or predicated on moral realism, which then brings us to a different question, which is, why is it the case? I sort of asked you first why social compact theory and moral conventionalism seem to go together within the tradition. Why is it that moral realism, if it's the only way that consent-based theory could be properly predicated, why is it the case that moral realism seems to fit within an organic conception of politics? And you can explain what that is as well.
Yeah, right. So, a scholar that I deeply admire, but I'm going to take issue with him here. The late Daniel Judah Elazar, and if folks are interested in the study of covenant, he has a 4-volume series. Beginning with ancient Israel, the first volume it gets it to the Middle Ages, second volume on the Reformation, and then a couple of volumes that deal with the United States. Elazar is maybe the foremost scholar of covenant in the last 50 years or more. I say that I build him up because I'm going to be a little bit critical now. He says that there are 3 models of political organization. We could sort of bracket one as more or less conquest, right? So if we're not dealing with that, he says there are 2 others. He says there's the Greek Hellenistic organic model, and you can put Aristotle, and he thinks you can put traditional natural law and Thomas Aquinas in that camp, more or less. And then there's the covenant model, which he says has roots in ancient Israel and biblical Israel, and focuses primarily on the recovery of that model by the Reformation and preeminently folks like Bullinger and Althusius, and he would say that the federal or covenantal wing of the Reformation is at least distinct from the Calvinist wing. I know that sometimes you get Reformed theologians and Calvinists who say this is covenant theology, and Elazar would say those are actually distinct strands. And he would say that with the covenant model, we are dealing with artifice and construction. And he would say Hobbes is a theorist in the covenant strain. But Elazar, to his credit, would also say that a covenantal theorist need not be a member of the Via Moderna on metaphysics. He would point out that Bullinger and Althusius believed in a real objective good. And then on the Hellenistic organic model, he would say Aristotle's the preeminent theory here, and he says, Aristotle views political order as a natural and organic, and there's a kind of almost automatic growth or development, right? That comes with that, and it's contrasted with political order that is a function of construction and artifice. Now, for all his brilliance in dealing with covenant, I think that Elazar doesn't understand Aristotle. For Aristotle, it is certainly the case that all organic things, like my dog back there, the squirrel on the road, the live oak in front of my study here, that these are organic things, and all organic things are natural, and exhibit a kind of process of growth from internal potentialities being actualized. But also for Aristotle, organic things are a union of form with particular matter. And he calls this union of form and matter substance, right? So a particular human being is a union of the soul, which is the form of the body, with particular matter with the body, and a particular human being is a substance. A particular tree or an acorn or the squirrel, those are substances. But a polis is not a substance. It is not a union of form and matter in that way. A polis is, for Aristotle, natural, but I think we get the genus-species stuff turned around. All organic things are natural, but not all natural things are organic. A polis is natural in the associational teleological sense. Now, organic things have teleology too, have purpose, have inbuilt purposes, and the goal of the polis, according to Aristotle, Aquinas I think modifies him here, but is the highest good, the final end, that which is good for its own sake, and not for the sake of anything else, and everything else we desire for it. Again, Aquinas I think modifies that, but and for Aristotle, the naturalness of the polis is something like this. Individual human beings have certain lacks. We are not able to provide for daily needs by ourselves. We need something to complete us in that area. And the household, he says, does that. The household exists to provide daily needs. But a household can't really provide more than daily needs. And so we need something more for that. And the village exists to provide more for daily needs. It turns out the village can't protect us from raids, and so we build the polis, which originally means a citadel or a fortress, but comes to refer to the city and its surrounding villages. And Aristotle says it comes into existence for the sake of life, but continues for the sake of well-being, as a partnership in the good life. And with the polis, he says, we have everything we need and nothing else is lacking. So the polis, and here I'm really drawing on Fred Miller's work as much as anything, the polis is natural in the sense of providing a kind of fulfillment of human nature that is not provided for completely at the other stages. We need a polis not only to live, but to live well, to thrive, to realize certain dimensions of humanity. But that doesn't make it organic. And in Aristotle's work, he very often talks about the importance of the lawgiver, for instance, right? And he doesn't say that human will and construction is uninvolved when individuals form households, or certainly when households form villages, or when villages form the polis, right? It's something for something to be, it's possible for something to be constructed and natural. It's a question of building with the grain rather than building against it. And so, so the first move is to say that Aristotle is a moral and metaphysical realist. We have real natures, real essences, and he is an organicist about some things, but he's not an organicist about political order and constitutions. They are natural to us, right? I'd make a point analogous to what Aristotle says about the virtues in the Nicomachean Ethics. Aristotle says that it is natural for us to acquire the virtues, but the possession of the virtues is not natural. That is, we don't possess them by nature. We must acquire them by habit, and their acquisition is natural to us, but having them isn't. So there's some will and action, and so also with the polis. There's the lawgiver, there's the decisions of households to form villages, and villages to form a polis, and these can be built better or worse. So I think that he is not an organicist. That sort of opens the door. By the time we get to the Salamancan Thomists and some of these counter-reformational figures, early on some Dominicans, later some 16th and 17th century Jesuits, like Bellarmine and Suarez, they posit a state of nature, whether it was referring to the time after the fall and before the advent of something like larger political order. They posit a state of nature, and they posit it as awful because of human selfishness and human partiality, and you can't live well in it, and you can barely live in it at all, before Hobbes says any of this stuff. And how would people leave it? And they say, well, they're equal. So it would take their consent to leave it, to form a political order. The consent of heads of households and things like that, a kind of corporate, natural, the family or something like that. But heads of households, and they consent together to create a political order in order to escape what they call, before Thomas Hobbes, the statu or status naturale, the state of nature. They're using this phrase. Hobbes actually lists this phrase. He doesn't invent it. So what are they doing? They're doing something, right? And they're insisting that it be done by consent, given human equality. I think that we find a way to think about this in Aristotelian terms in the covenantal thinker, the federal theorist, Johannes Althusius. That's not to say the founders read Althusius, or one should agree with everything in Althusius, but there's an important move here. Althusius, commonly regarded as this at least early summit, this sort of zenith of covenantal thought, and Eleazar treats him as such. Eleazar is a huge fan of Althusius and his work, and treats him as covenant rather than Aristotle. But if we read Althusius mentions Aquinas, is deeply indebted to a Renaissance Thomist named Vasquez, Fernando Vasquez. There's two Vasquezes, and invokes Aristotle. And he invokes Aristotle's causes. In his Physics and Metaphysics, Aristotle talks about 4 causes of a thing: the material cause, what it's made out of; the efficient cause, which actualizes the potential to make something to be. Maybe we think of the action of the chisel on the marble in creating the David as part of the efficient cause. The efficient cause of the oak will involve the sunlight, the nutrients, water falling from the sky, etc. The formal cause, the essence of it. What is it? It's whatness, or in Latin, it's quidditas. And then finally, it's final cause, right? It's telos. It's why. So the 4 causes of any given thing. So if we're dealing with Michelangelo's David, we'd say the marble is the material cause. That which brings the David out of the marble involve the chisel and the mallet and all that. The efficient cause. The formal cause, we could say that it has the form of a man in a sense, analogous. Aristotle would say if it really had the form of a man, it'd be walking about, and reasoning. It's not, obviously. And the final cause, maybe it's beautification. The final cause of the light bulbs in this room is to give light to the room, of the eye to see, of the heart to pump blood. Althusius says, he adopts this scheme, he embraces it, and he says the final cause of political order is well-being. I mean, it includes preservation, which it would include for Aquinas. Hobbes reduces everything to preservation. Preservation is not unimportant. It's Hobbes' reductionism that's the problem. It includes that, but it's also it's well-being, and it's all the constituent things of a good life, of human thriving. And he says, and the efficient cause is consent. And we find the anti-federalist Brutus saying something like this in his critique of the Constitution, but it seems to me an idea that's at least implicitly elsewhere. He says the final cause is the common good, the efficient cause is consent. And I think we can say, listen, yeah, insofar as human beings are equal, then consent is necessary as the efficient cause of political order, of a regime which, if it's properly framed, the common good, or the good of the whole, is the final cause. And so I think that these can be reconciled on Aristotelian terms, but I think what Althusius helps us to do is to see a way that reconciliation can go, and a way that means that there is no logical, and I would say no logical contradiction, I'd say no contradiction of any other kind, between covenant, rightly understood, and Aristotle. And in that, I've drawn a bit on Fred Miller. I think that Miller has Aristotle right here, but also the fact that key covenant theorists were not they didn't say, oh, Aristotle's an organicist, we can't use him. They said, here's how this goes together, and it logically coheres.
I mean, if we had more time, I might ask about Burke and his sort of organic conception, his critique of the social contract theorists. But I think this has already been going for quite some time, and you're a great sport for sticking around, and I know you have to go soon. So I think this will be the closing question, which is, I see clearly, and I think the listeners by now will hopefully see clearly, not only the not lack of contradiction between social contract theory and moral realism, metaphysical realism, but actually the necessity of those things together. in order for social contract theory to work. But then that takes us to something that we've been, I think, dancing around a little bit, is the real consent, the practical problem. And then I might even tie that back into a theoretical question as well. So let's see how it comes together. Is, and you kind of pointed this out, like most citizens don't actually consent to their government, at least in a sort of formal express way. I've never sent in a piece of paper to the government. I consent to be ruled by you, Congress, or, but I grew up here. I was raised here. I said the Pledge of Allegiance as a child without really understanding what I was saying fully. Now, granted, I do consent to be ruled by this government, and it's not just because of the president, but because it's a regime to which I want to be. But I've never really said that expressly in any formal legalistic way or any pre-legalistic way that gives binding force. And in the same way, that's true of most people, except maybe like naturalized citizens or public officers. So, and you point to this in the book, is, how do we deal with the real problem of consent? And then I would maybe just ask one question, is to problematize if we're all equal, do we actually need consent? Is consent the big deal after all? Could we just say that, the organic model has the sort of the features of a social contract, but it's not done in this sort of formal way, but like the medieval kingdoms of old could be reconciled with equality, even though there's no sort of like formal animating principle of consent. Does that question make sense? Is it too big?
Oh, it's fantastic.
Good.
It raises the central problem. I started on this particular project while in the midst of, I think, wrapping up a dissertation, although it might have been wrapping up the first book. And Jay Budziszewski hands me an essay by Nick Wolterstorff and a response that he gave from a conference that they'd both been at, now published. And Nick raises this question, and he points to the fact that, if you will, an awful lot of political philosophers in philosophy and a lot of legal theorists, including some prominent ones like Joseph Raz, have raised questions along these lines, and says that the big problem here is that hardly anybody has given any consent. And Nick was up to something interesting. The argument he was moving towards was the necessity of divine authorization or ordination of political order for it to be rightful and legitimate. And I actually think that is compatible with consent theory, understood a certain way. You'll see that Nick's one of the endorsers of the book, so we're not far apart. I then, down the line, read A. John Simmons' book, The Edge of Anarchy. And Simmons says that for Locke, and for himself also, consent is necessary for political obligation and authority. He says it's not sufficient, but it is certainly necessary. Locke was right to hold that, perhaps on grounds of equality. That's, I think, the real ground in Locke, and I would underscore that. Simmons predicates it on what he calls natural liberty, and I think you can find a sense of that in, say, Suarez or Bellarmine, but I tend to think that the real ground for the necessity of consent is human equality. So Simmons says, for Locke, consent is necessary, and Locke's right. And he says, but, David Hume pointed out that consent is great. Hume probably thinks consent is even sufficient, and Hume's wrong about that. But Hume points out that hardly anybody in any regime has given consent, which would seem to delegitimize all of them. Hume says, you announced this theory. He says it may even have been true of really primitive regimes. I think that we know that the earliest regimes were kingship or sort of priestly rule that collapsed into kingship or it evolved into kingship. But there's this theory out there that, there's sort of an early primitive democracy. And not only the American Puritan John Wise, and the American radical Thomas Paine subscribed to that sort of theory. Certain of the separatists subscribed to that theory. But Hume seems to think that was the case, that maybe early on. But he says more or less it's not the case now. And if you were to announce that regimes are only, that the people ruling only have authority on the basis of consent, you'd be laughed out of court. Most people know they haven't given their consent to these regimes. And then Simmons begins to say, okay, people haven't given express consent, explicit consent, signed on the dotted line. There are express consenters. In our regime, people who go through naturalization, right, raise their hand, recite. If you are a member of the U.S. military, and this would, you need to say, not have a draft. If you're a voluntary member of, so that coercion, so it's voluntary consent that matters here. Or if you're a member of a U.S. or state government, you've given consent. I think that Simmons would say he thinks that that's a really small percentage of our population, 5%, 10%. A friend of mine who doesn't necessarily want his name out there with this because he did an informal count once. He hasn't published it or anything, and I think he'd want to check it. But he thought it's possible that the number in the United States is more like 40%, which really surprised me. But that still leaves 60%. Regimes claim to rule over everyone in their territory, and even at 40%, that leaves most everyone uncovered on express consent, right? So express consent, signing on the dotted line, if you're in government, if you're a naturalized citizen, if you're in the military, we can call those the express consenters. And we still and even in Locke's day, most of the people in England, we know he wrote the second treatise earlier in the 1780s for a revolution coming, rather than, as the preface suggests, to make William's throne good. But I think he's really interested in that too. He knows that there's a paucity of express consenters. And so what does he do? He says express consent is the gold standard that you need for full membership, and that's for the full privileges and the full duties of citizenship. But with respect to an obligation to obey the law, tacit consent will do the trick, right? And for Locke, you say, what are the signs of tacit consent? And it's something like enjoying the benefits of the place. So things like residence, use of the inns and the roads, and enjoyment of protection. And you said with express consent, we had a paucity of consenters, and with tacit consent, it seems like everybody resides. Uses the roads, enjoys protection to some degree or other. Maybe in some societies, there are some people who don't really enjoy the protection of the place under slavery or in a genocide situation, or something along those lines. But a lot of people enjoy the protection offered by a regime, and that would seem to set the bar pretty low. And if we want conscious, voluntary consent, residing and using the roads doesn't seem to give us that. So, but Locke relies on what tacit or implied consent. And Simmons says something interesting. He says, tacit or implied consent can be voluntary, conscious, and specific. It just doesn't seem like we have any signs of that anybody's talking about, and that anybody's come up with for modern constitutional regimes. And if you say, well, what about voting and participation? And the answer is you already have to be a member of the regime to vote and participate, right? It presupposes what it's trying to justify at the end of the day. So voting and participation wouldn't work. The Pledge of Allegiance, we start saying from when we're very young, and most people just sort of say it rote as habit. They're not saying it with the sort of conscious intention of giving allegiance and what that means. I'm sure that some are. I'm sure that some have, right? But for a lot of people, and it'd be hard for us to know, it might just be habit from when they were very young. And so you say, well, doesn't this seem to raise a problem? And so you say, well, express consenters are few and far between. We don't have an adequate sign of tacit consent by which many people have given consent to obey the laws. Well, maybe we move from real consent to hypothetical consent. After all, Thomas Hobbes does not mean to describe a historic condition with the state of nature, for instance, right? And other theorists sometimes say, well, yeah, it may have been historical, but we're talking about justifying, like Locke, political authority and obligations here and now. And so, for us, the state of nature doesn't matter in that sense. Jean-Jacques Rousseau says it's not a historical state of affairs, or if it is, it's nothing that we can know, and it doesn't really matter. The thing with Hobbes, and there are, of course, in conservative circles, for instance, there are folks who take the hypothetical Hobbesian consent route. Michael Zuckert, for instance, frames Blackstone as a hypothetical consent theorist. I'd point out that for Hobbes, of course, the state of nature is not a historical state of affairs, or the pure state of nature, to borrow from L. Martinich, the condition of mere nature, as he calls it. When we get to the end of chapter 13, Hobbes says, it may be objected that this state of nature, this condition of mere nature, has never existed. And I believe it never generally has the world over, he says. And then he gives 3 instances that are, including things like civil war, the governance of small families, all you have are petty kingdoms, tribal kinds of things. Like maybe you had, I'm part Scottish and part Irish. I think, the Irish and the Scottish probably have the governance of petty families in this sense, right? And he mentions indigenous Americans. He may be wrong about that from when he was writing. I don't think his source was very good, but Thucydides' Prehistory of Greece seems to sound like moving. And he says, within these tribal groups, maybe even think of ancient Israel until the monarchy. Now and then you have a judge, right? But within these tribal groups, you don't have a state of nature within them, but you do across them. It's not the mere state of nature, right? A civil war, or the nations of the world, you don't have a state of nature within these things, but across contending sides in a civil war, across the nations of the world, not within them. But he concedes the mere state of nature never really never existed. And in fact, I mentioned that he thinks of ethics and politics as a science. And he thinks of science like geometry, as he frames it, as purely deductive and a priori. That means prior to experience, right? And so if politics is a science in that sense, that the state of nature's function in it, for Hobbes, is not as an experiential reality. That doesn't matter for him. It's not as something that we've been part of, and its historicity doesn't matter. What matters is this is how it would go, the war of all against all, in which life is solitary, nasty, poor, brutish, and short. This is what the state of nature would be if it existed. And he says that more than anything, human beings want to avoid sudden and violent death. The worst thing is to live in continual fear and danger of sudden and violent death. And so you'd want to get out of it if you could, if you found yourself in it. Not that anyone ever has, not that you ever will, but if you did, then you would choose to leave it if you could. It's a hypothetical, as it were. And so what then is his covenant of everyone with everyone? Hobbes will take real consent if he can get it. Real consent suffices as far as he's concerned. But hypothetical consent is what's happening in his covenant of everyone with everyone. The point is that the state of nature is so awful that you would leave it if you could, i.e., you would want to avoid falling into it. It's forestalling the state of nature that's in view. And so you would choose, he thinks, absolute, indivisible, sovereign power, because that's what it takes to escape and avoid the state of nature. Hypothetical consent. But, as we noted before, a hypothetical promise isn't a real promise, and it doesn't bind anyone. Hypothetical consent is not, that's why Locke is looking for some kind of real consent, because consent theory is about promissory obligation. And so you've got on the one hand Robert Nozick riffing a film producer, hypothetical consent isn't worth the paper that it's not written on. You've got the liberal legal theorist Ronald Dworkin saying that hypothetical consent is not a pale form of real consent. It's not consent at all. It's less good than the other quote, but it's still good, So what do we do? I think the answer is, insofar as we are human beings really are equal, we need to pay due regard to it, is that when it comes to political foundations, we need to be dealing with corporate consent rather than purely individual consent. Now, on the covenant model of Althusius, there's a role for individual consent in forming a household, right? And informing congregations, probably on his view, certainly informing guilds and things like that. So individual consent comes into play, not with respect to the whole family, children with respect to parent, not that, but and he builds to what he calls these private natural associations, and then those covenant together to create the first level of political association, right? And I think that's one way that you could go about things. In fact, I think it's actually the pattern echoed here, not by folks who read Althusius, but by folks who subscribed to covenantal thought, often picked up in Holland, perhaps, or there was traces moving between Holland and England. You might pick that up. And I think, if you will, they put into practice what looks like the Althusian theory. They never read Althusius, but it's sort of a separate, independent discovery. And what you have with the Mayflower Compact, I hate to call it, it should be called the Combination or the Covenant. That's what they actually called it. But with the Mayflower Compact is you have heads of households agreeing to create a primary political association. And then you get settlements that band together to create something bigger. And it's a corporate private reality, as it were, creating a corporate public reality, and then corporate public realities that create something bigger. Or we can take the principles here to indicate something like popular sovereignty and not go farther down than that. I hate to use the word sovereignty, either coined or first used in politics in the 13th century. I'd rather just use words like rule. Sovereign means over or above rule, or over or above reign. But it's the phrase that people use. So I think that we can say either we need sort of a corporate level foundation before political authority, and I'm amenable to that. That really fits with the New England pattern. Or we say human equality entails popular sovereignty. That is, in more medieval terms, the right of the communitas to govern itself, right? And where Aquinas says a community can either delegate a government or alienate its power. And where it delegates a government, it retains authority over its power and the right to replace it if it abuses. And if it delegates a government and it becomes tyrannical, then you have an appeal to heaven, which means prayer, right? You can't actively resist in that case, although you can't go along with unjust laws. In particular, you can't obey laws requiring you to violate the Decalogue or divine law or to inflict serious injustice on another. But some later Thomists, including Cardinal Bellarmine, who's a pretty conservative Thomist, says, actually, given human equality, and this isn't a passage that Sir Filmer in Patriarchy just hates, given human equality, political authority always resides with the community. They only delegate its exercise, and they always retain the right to depose and replace abusive government. So, say, Bellarmine is reacting to what we might call the patriarchalism of James I. And there's this sort of back and forth, Bellarmine from Italy with against James I. Sir Filmer defends James against Bellarmine and Suarez, right? And later on, Locke and Sidney go after Filmer, where Filmer goes after Bellarmine, and Sidney is explicit about his defense of Bellarmine against Filmer. But it's right there in Filmer. Filmer's like, I hate natural liberty, and the only argument I can find for it is this, and it's Bellarmine's argument from natural equality to popular sovereignty, and to the right to depose tyrannical government that both Hobbes and Filmer hated, as contrary to modernist sovereignty. And what has Bellarmine done there? He's moved from natural equality to popular sovereignty. And I think that is a possible route to go too. That's the route Nick Wolterstorff would go. But as a matter of practice, purely individual consent, I think, really is unworkable. But that line of thinking can redound to coherent and workable accounts of corporate consent, as long as they're framed in a way that pays due regard to human equality. So something like Republican form.
Well, excellent. On that note, we'll have to end there. I'm sure there's much more we could say, but this has been already a great episode. And Paul, I appreciate you taking so much time out of your day to come join and talk about it with us on the podcast. So thank you very much. And
thanks for having me. Really appreciate it. If people
want to follow more of your work, keep up to date with other articles you're writing, or other books, what would you recommend to our listeners?
I have an account on X, and I post things there, and so if something's coming out, I'll announce there. I think my university webpage, new stuff usually shows up. You probably met the book that we've been discussing with Missouri Press, The Social Contract and the Ruins, and then my first book, which I hope is timely, Uncovering the Constitution's Moral Design, which is on the natural law, Aristotelian Thomistic natural law foundations of the Constitution's order, which I think is sold out in hardback, but you can still get it at least from Missouri Press in paperback. I probably should have a website. I'm not sure I'd be terribly good at that sort of thing, but I am on X, so yeah. For the annoyance people, I think.
Well, thanks again, Paul.
Thanks for having me.
Thank you for listening to Conservative Conversations with ISI. If you've enjoyed this episode, be sure to check out our website at isi.org/resources to see all that we offer our members, including the Intercollegiate Review, select modern age articles, debates, lectures, and of course, this podcast. Thanks again for listening. Don't forget to rate and review, and we will see you next time on Conservative Conversations with ISI.